What do we mean? Okay. There is this novel by.
Hello? Okay.
Yes. There is this novel by T.M. Aluko. I don't know how many of you have read it. Very interesting novel. One man, I think it's one man, one machete, not one man, one wife. That was the case where the people of a community were eyewitnesses to the killing of one of them by another one among them. And they swiftly, I won't use the word arrest, but they were about to swiftly do their own kind of justice on the man who had killed another. And the district officer then came and scared all of them away, arrested a few of them together with the killer. And the people in the village were so angry. What manner of thing is this? Right in the presence of the DO, right in our presence, somebody was killed. And what else does the person who kills another deserve than to be killed himself? And we are just about doing that. And the DO scattered all of us and picked the person. Okay? And so, but the DO subjected the person to a trial, his own type of trial. His own type of trial where the court process was followed. At the end of the day, the man was found guilty and sentenced to death. So on the day of his execution, the people of the community were then wondering, what a waste of public resources. Why did he have to waste all that time when it is right in our presence that the man committed murder? So the colonial master had demonstrated his commitment to due or judicial process. And on that occasion, because due or judicial process eventually arrived at justice, the complaint of the people was, what was the need for the delay? Why did we not kill the man immediately, allow the man to be killed and all of that? So, what is it about the judicial process, not necessarily from textbook, whatever, that we can say in terms of his workability, in terms of his advantage? Do you think it has disadvantages? How can a legal system operate without due or judicial process? Is it not a recipe for anarchy? Okay. One of our foremost theorists of the analytical positivist group, HLA Act. Remember how he defined law? Said that he will not define law in terms of individual rules. He said he would define law in terms of the legal system. He then said that a legal system is a combination of primary duty imposing rules and secondary power conferring rules. We went ahead to break down the secondary rules to include that of the judge. The judge's judicial power is a secondary rule that you have to add. You have to combine with the primary rules in order to have a legal system. The primary rules would impose the duty, impose the obligation, direct you as to do's and don'ts. And then when you violate the do's and don'ts, what happens? If you have a legal system, some secondary power of adjudication, okay? Secondary powers of investigation, arrest, adjudication, and what have you, must then exist in order to ensure that secondary powers of enforcement also, they must then exist to combine with the primary duties, primary rules, in order to have a legal system. So that is how a jurisprudence defines the legal system. Okay? So in the light of this, my own contribution, let me have comments from you, especially referencing happenings in Nigeria. Okay, it's a jurisprudence class. And we are doing applied jurisprudence. What one event in Nigeria will you use to illustrate either pros or cons of combining the secondary power of adjudication, the secondary power of investigation, the secondary power of enforcement, together with the primary duty imposing rules? And what would have happened if you separate the two and you decide to act the way the community in Tiema Lucosnovo wanted to do? But this is a person, we saw him killing somebody. Why are you wasting time? Why are you wasting time? Isn't it the rule, even in the holy books, that he who kills must die? So, contributions. So we are on the judicial process now. Yes, all of those issue of criminal, civil, and all of that, they are elementary things, and we know them. In the jurisprudence class, we want to talk about the importance of due process, the importance of following through the secondary rules, either of enforcement or of adjudication or of hearing and what have you. Okay? You have nothing you want to say. There is nothing going on currently in Nigeria that will make the topic judicial or due process important. If we were to address Nigerian practicing lawyers and the judges about the importance of the judicial process in the light of some of the things happening in Nigeria, which particular thing will you likely refer to, and what are you likely to say?
So if I may just quickly add that the nature of judicial process in Nigeria is mainly characterized by adhering to the rule of law. And in adhering to the rule of law, it's important to follow through the process of the law. So if a man has committed a crime, there are provisions in the law that makes provisions for fair hearing, even if he's caught in the act. There are provisions in the Evidence Act, how his plea must be taken based on the provisions of the Criminal Procedure Act and other relevant acts. And the judge, in adjudicating on these matters, must adjudicate in line with the provisions of the law. And something that comes to mind, it was the case of Awolowo and State during his charge for triple felony. When Mr. Sowore J said that, well, if it was to be in his opinion, he would have asked Awolowo to go after standing trial. But his hands are tied because the provisions of the law, are very, very clear, and the evidences before the court are such that the only thing he could have done at that point was to sentence him. So if that is a position of the rule of law, and as long as we are aware and understand that the Nigerian judicial process adheres to basic principles of the rule of law, we must understand that a judge going against those laid out provisions will definitely amount to what the Supreme Court has said in some cases as an act of judicial rascality. So we must understand that point, that judicial process in Nigeria is based on the rule of law, and the judges must adhere to the rule of law. The enforcement agents too must adhere to the rule of law, and all these things holistically forms, part of the Nigerian judicial system. Thank you, sir.
Very well. I was expecting you to give me live things. You are talking about Justice Owemima of Blessed Memories statement, which the action group has termed to mean that his hands were tied by the authorities. But they were being mischievous because the
Of
man
course.
was saying that the law has to be followed and all of that. Well, that's a good one. I thought you and your class members, we look at the way the politicians are dealing with
Hello, sir.
issues of law. Yes. Yes.
Hello.
Mr. Mohammed.
Yes, sir. Good evening, sir.
Yes. Mm.
Okay.
We are on judicial process.
Yes, sir. Yes, sir. So, in addition to the point on judicial process, essentially, on the need to adhere to lay down procedures, especially when judicial officers are exercising their judicial powers in terms of, settling disputes, interpreting laws, both in civil and criminal matters. And a very good live example that came to mind, and in relation to how politicians have been, have come into the conversation, is the conviction of the former governor of Abia State. I mean, I find the scenario very interesting. We could recall that Honorable Justice Mohammed Idris, who is now at the Supreme Court, was the trial judge before whom this man stood trial. That's Senator Orji Uzor-Kalu. And, before the trial had been concluded in that matter, and before the judgment was passed or delivered, the trial judge, Honorable Justice Mohammed Idris, was elevated to the Court of Appeal and sworn in. And of course, there is this very interesting provision in the Administration of Criminal Justice Act of 2015, Section 396 of 7, that says that a judge of a high court who has been elevated to the Court of Appeal can continue to sit over a matter over a part-heard matter pending before his elevation, on the condition that if continuing that part-heard matter will not make him assuming a position of Justice of Court of Appeal. But in that matter, Honorable Justice Idris Mohammed convicted Senator Orji Uzor-Kalu after he was sworn in as the Justice of Court of Appeal. So the matter went on to the Supreme Court, and they challenged the decision of the Court of Appeal in that case as to whether it was proper for Justice Mohammed Idris, who has been elevated to the Court of Appeal at the point, whether it was proper for him to deliver judgment in that case. And the Supreme Court came to a unanimous conclusion that Honorable Justice Idris was wrong to have, delivered that judgment, not minding the fact that he was, he was the one who, who had the matter and delivered judgment. So essentially, the Supreme Court emphasized the need to comply with the provisions of Section 396 of the ACJA on whether the Justice of Court of Appeal could preside over a part-heard matter. Until today, we could see that despite the fact that the Supreme Court said that judicial process that should have been followed was not followed, the matter should be reassigned to another judge of Federal High Court for arraignment and trial. And as we speak, nothing of such has happened, because what eventually happened was the Attorney General of the Federation just exercised his power under Section 174 of the Constitution. So a community understanding of this is is leading towards to what extent is judicial process even effective in Nigeria. And when we understand what played out in this process, we realize that beyond judges doing their work, there was some element of political interference. because the Supreme Court's directive in that case was even that the matter should be reassigned to a judge for trial, and nothing of such happened in the end. So my opinion essentially is that, yes, judicial process is very significant to administration of justice in Nigeria, and essentially it emphasizes the need to comply with the laws. But when we look at what plays out in reality, we can simply say that judicial process in Nigeria is a beautiful bride that can neither conceive nor give birth to a child. Thank you.
Very interesting. What is the alternative then? What is the alternative? Yes, you have given us an example of instances when our own corrupt nature set in. Okay? By insisting that the matter should begin de novo before a trial court, the Supreme Court had not done anything wrong. They had complied, they had cited and relied on rules for that. Okay? Again, the Attorney General has the power to enter a nolle prosequi or to discontinue or not to file charges. Whichever way you look at it, everything has been done according to law, but law has not been employed to serve the end of justice in that instance. What is the alternative?
All right.
Are we going to be worse off if we say, okay, forget about judicial process? At the end of the day, it is what some persons of authority want to happen. Will happen. So why are we wasting our time? We have 75% of the people, that's their view. That's their view about all the shenanigans that we do, going through court and all of that. And the outcome of any cases, we lend credence to their own suspicion. Even when you would have one technical or other excuse to explain it away. Okay? Will the alternative be forget about courts, forget about judicial process? If we forget about court and judicial process, what is going to happen to both the wrongdoer and the complainants? Okay? Any other comment? Any other comment? Okay, let's discuss a live issue. In Rivers State, we are told that we know that some 27 members of the House of Assembly allegedly decamped. They did things that you can conclude that they have decamped from the party that brought them to power. We know what the Constitution says. Okay? Assuming they truly decamped, the Constitution says that disqualifies them to remain in the House. But goes ahead to talk about what would happen in declaring the seat vacant. One side of the argument says that once they have decamped, they have ceased to be members of the House. And that is the one that Femi Falana and others are championing. Okay? They're not championing it for free anyway. They've collected a lot of money to argue that way. From a jurisprudential perspective, assuming they have decamped, why should anybody wait for a court? Why should anybody wait for a speaker to declare them vacant in circumstances where the speaker is one of them? Wait for their parties to take them to court to ask for them to relinquish their seat, and wait for a court to pronounce that their seat has become vacant by way of their decamping. Why not treat all of that as already happened, and proceed, which is why Falana's line of argument, as if they have all ceased to be members. Insofar as it serves the political motive of one party. Okay? Can I have opinion on this? In the light of due or judicial process, why should the Rivers people patiently await the Amewile 27 members of the House to hold them to ransom, including the possibility of impeaching their governor, all in the name of due or judicial process? We have listened to people who have told us that, yes, what Femi Falana is saying is true and these authorities are correct, but the provision is not self-executing. It is the speaker who will declare the seat vacant. If he does declare the seat vacant, the opportunity then will be given to, and if he doesn't declare it vacant, his political party it is, the political party of the decampees it is, that will go to court to get an order of the court declaring the seat vacant. Before, you saw that even pressures on INEC said, we will not do that until we get a court order. Why must INEC wait for a court order? Yeah? Falana argues that those provisions are self-executing. We should move forward and assume that the moment they declare themselves to be members of other political parties or another political party, those seats became vacant. And all of his argument too is to serve a political end. the survival of the governor, and all of that. So let us discuss this in the light of the pros and cons of due process. Remember what I said, that many a times the duties are clear, and even the blind will see that the duties have been breached. But our legal system will still insist that you follow the due or judicial process in order to hand out punishment to the person who was guilty of the breach. Why should we wait for that? Why is Femi Falana's interpretation not correct? Why should the governor still be expected to go and present a budget to the House consisting of speakers, legislators who by their decampment and going by the black and white of the Constitution have lost their seat? So, opinions on this. From a jurisprudential perspective, please. No comment. No comment.
Hello, sir.
Yes.
I have a comment to make, but not on this. But it's actually a current issue.
Yes.
Okay, the case of Nnamdi Kanu and the federal government of Nigeria.
Yes.
The case of Nnamdi Kanu was not extradited to Nigeria. It was not by due process of law. He was bungled, he was arrested, and then brought to Nigeria, and then brought under the auspices of Justice Binta Yanko. And he is alleging that the judge is biased. And though Nigeria practices an adversarial system where one person can, argue his case before a judge in line with Section 36 that gave everyone the right of fair hearing. So he told the court that he was going to make a representation, and he did his own legal representation. And then he alleges that the judge is biased, and that the process is illegal, the process is biased. And if you look at it, the due process have been subverted. And Lord Denning said in the Locus Classicus of UAC and MC4 that if an act is void, it is in law a nullity. It is not only bad, but it is incurably bad. But you cannot put nothing on something and expect it to stand. Once the process that brought him to court is faulty, the process is illegal, the judgment that comes from that court cannot be legal. So it's actually because of the fact that there is no due process, there's a high tendency, there's a high possibility that the course of justice will be subverted. That's my take on Nnamdi Kanu and the federal government of Nigeria, sir.
Yeah, but there is also the argument. The Nigerian position has always been. I know that when it comes to evidence, the position has always been that the manner of procuring evidence will not affect the validity of the evidence. And I think that there are Nigerian cases too.
Legally obtained evidence is admissible.
Hello?
illegally obtained evidence is admissible.
It's admissible. And
Yes.
there are other issues. Many of these things are arguable. Do you understand?
Okay, sir.
I think that the Nigerian position would appear to be that it's without prejudice to the reliefs he may seek with regard to the extraordinary rendition. Is that not what they call it?
Yes, sir.
The manner in which he was brought and all of that.
Yes.
Okay? The court will say that what is before me is the alleged crime that you committed, which I will give you a fair hearing to defend yourself of. It's without prejudice to the other rights. I know that the position is different in, I think in America. In America, they tend to link the process of arraigning the suspect with the legality of the trial itself. Countries may have different opinion and all of that, but well, fine issue.
I have a comment, sir.
Yes.
Sir, I would like to dwell on what the first speaker, I think Adams, what he said about the act of Honorable Justice Idris. Then I would like to say one or two things about the River State. You know, sir, I think one of the problems we have in Nigeria, particularly the judicial system in Nigeria, is the fact that we have allowed ourselves to be used as as a tool by the politicians. And as a result of that, we have become, I don't want to use the word dishonorable individuals. You know, and why did I say so? You know, Adam said, Honorable Justice Idris, emphasizing the position of the ACJ in respect of the governor that was convicted before he went to the Court of Appeal in 2019, and then now in the Supreme Court 5 years later. I want him to look at it from the fact that that singular step may be a deliberate step calculated to get the convicted off the hook. Because if that step was not taken, maybe the non-lead prosecutor assigned by the Honorable Attorney General would not have been. And now, why did I say so? You know, a lot of schemes, political schemes, find their ways into our justice system. And that gives an impression that we are sitting on a very dry gunpowder. Now, with regards to the River State issue, it's like a tenant who made up his mind to deal with his landlord, knowing fully well that it's a statutory tenant. Now you give him or her a notice. What the tenant will be looking for is a loophole in that notice that he can explore. Now, maybe the members of the House of Assembly of Rivers State would have been very honorable to say, "Oh, this is the position of the Constitution. Now that we have defected to another party, we should go home," including the Speaker. But these guys would not go. They are not honorable. They are not men of integrity. They refuse to
agreed
go.
with you that they have decamped. They have not agreed with you that they have decamped.
Sir,
But we all know
agreed.
that that's what they did mean.
Sir, they've not agreed that they have. Yes, they've not agreed that they have decamped. But obviously, there are finger pointing to that direction that they've actually decamped. Now, they refuse to leave. The Honorable Speaker is part of the people purportedly decamped from PDP. Now, the Speaker himself would not in any way declare, because they know the benefit attached to the office they are occupying. They will not go on their own, no matter what. They will rather let the judicial system, which will give them right of appeal up to the expiration of their term, to start wasting and be bothering themselves about whatever the fact of the matter may turn out to be. So I think that's my position. I think it's on the basis that we are very, very dishonorable. The people we call honorable are dishonorable, and the judicial system had allowed themselves to be used by the politician to achieve their.
Do you think it is the fault of the judiciary? Do you honestly think it's the fault of the judiciary?
As it is, it's not the fault of the. It may not be
It's
the
not
fault
the
of the
fault of the
judiciary.
judiciary.
It may not be. So we
It
can't say
cannot
it
be
is
the
not.
fault of the judiciary because even those of us who are willing to ignore the entire facts and comment on their alleged decamping, we ignore the fact that the man they were fighting himself, he wanted to use bulldozer to bulldoze the House of Assembly. Do you understand?
I'm with you, sir.
So you see, politicians, what we continue to see in Nigeria is you see that when Party A is involved, we sympathize with Party A. But tomorrow, Party A will soon become the assailant. And we do exactly the same thing that Party B has done. The idea of, because of the fear of impeachment, blocking members from having meetings in the House itself, is not a gentlemanly behavior. Is it a gentlemanly behavior?
No, sir.
So we have rogues versus rogues. And when you have that type of situation, you can't expect any honorable thing to any honorable behavior to come from them. The politician will tell you one thing, but what he has in his mind is another. The politician will tell you he's ready to follow the law, but as he's telling you, he's looking at how he can sidetrack the law. He's looking exactly at how he can sidetrack the law. So, but in the particular case of the Rivers 27 members of the House, can it be right? Can we say because of their dishonorable nature that we can forget about judicial process and just take it that the moment they did this has happened, and continue as if it has truly happened without waiting for any court note? Is there a difference between that and in the TM Aluko story, the DO watching by, saying that, look, after all, he also killed someone. Let them deal with him. Which the DO refused to do, only to eventually ensure that the killer went through a judicial process and he was convicted. Suppose he had a defense, a valid defense, or suppose he had a defense that would commute the murder to manslaughter. Shouldn't he be listened to? So we cannot shout judicial process when it suits us. And when it doesn't suit us, we shout Femi Falana. We say the thing is self-executing. It has happened, it has happened. So the governor should go ahead, pretend that they never existed. But that's the entire argument. pretend that they never existed. Whereas we all know that one thing led to another. One thing led to another. So the fact of their decampment, we want to say, should now be a cover-up. It will serve as a forgiveness for whatever it was that the governor might have done wrong previously. All of us have sides in this matter. And so those who are in the side of the governor, they are not exactly proud of what the governor sought to do. But they don't think that that should produce a consequence. They emphasize what the legislature sought to do, which they have not even done. And present an argument that it has been completed. On the legislature side, they say, well, yes, we did the declaration. But where is the party card of the party we are decamping to? Have you checked the register of PDP and you don't find our names? What does the statute say? What does the constitution say should happen to us? And who does the constitution appoint? Do you understand what I'm saying? Whichever way you look at it, the fact that we always pick and choose when to subject our arguments to rationality and judicial process, it's not going to be because judicial process itself has a problem. It's going to be because we have a problem. We have a problem in that we allow our interest to override the law. Okay? So just take note of what it is I have said about the importance of judicial process. You see, these people, these presenters of today, they talked about so many things. Instead of talking about a few things and raising our curiosity. Okay? Their note on judicial process was very, very scanty. Very, very scanty. So you people should go and build up a bigger note on that topic and relate it to happenings in Nigeria. The likely conclusion you may reach is that judicial process can be relied upon to do injustice. Like the example that Mohammed gave to us. Okay? It can be avoided also to do injustice. And in my own view, that is what the argument of people like Femi Falana in the context of the River State imbroglio amounts to. Because it is one thing to violate the law, it is another to follow the judicial process to secure the due punishment. Okay, so you can follow the judicial process to arrive at injustice, no doubt. But you can avoid the judicial process too to arrive at injustice. And when we are talking about injustice, we are talking about injustice according to the law. Okay? So maybe what will be proper is for politicians to do their things their way and not to involve the law at all. Because each time they involve the law, they are doing so in a selfish manner. And on both sides of the divide, they will have lawyers. Everybody wants to survive. So if you have a fight for expressing an opinion, why will you not express it? Yes?
Good evening, Prof.
Yes, good evening.
Yes, sir. When you said we should relate this to our jurisprudential class, can we please state that we can relate it to the legal positivism theory that politicians should abide by the law the way it is? Going
I just gave an example of HLA Act.
Yes,
Of
sir.
how you
Thank you,
define
sir.
the legal system and
Yes,
the
sir.
role of the secondary powers of adjudication, secondary powers of enforcement, secondary powers to investigate. And they say that you won't have a legal system if all you have are rules that say you do this, this is your punishment, without having those secondary powers. And that if the secondary powers are not exercised, you are likely not to have a legal system, but an anarchical system where the type of thing that the crowd in TMO Aluko's story wanted will be what is happening. Okay? So, I just gave an example. You can look at other schools of thought and see how they can relate to this issue. Okay?
Okay, sir.
So, we go to the debate about judicial lawmaking. Leave judicial precedent for now. I'm afraid we have another class. We are going to have another class because it's a very wide topic. Judicial lawmaking. Leave judicial review. Judicial review is a constitutional law. And we are not going to bother ourselves about it. But judicial lawmaking. Let's go to judicial lawmaking. What is chapter 3? Do judges make law? Do judges make law from a jurisprudential perspective? Can we debate this?
Yes,
Whatever
sir.
we say when it is 5 minutes to 7, we stop. I'm sorry. I would have loved the class to end today, but There's no way we can take this topic in 2 hours. Okay? The subtopics are many. And you might be surprised that because they are all relevant to our polity, you might decide to bring more than one question on this paper. So let's talk about judicial lawmaking. What is your own view? It's an old debate. It's a debate that is as old as the legal system itself. What do judges do? Do they make law, or do they merely interpret and apply law?
Hello, Prof.
Yes.
Okay, good evening, sirs.
Good evening.
So my view is that, yes, judges make law. I mean, when we look at the meaning of law in line with different schools of thought, one can easily say that, yes, judges do make law. And there are constitutional and statutory backings for it. For instance, if you look at Chapter 4 of the Constitution, I mean, it is without that judges have the primary responsibility of interpreting laws and adjudicating over disputes. But when we look at Chapter 4 of the Constitution, that makes provision for fundamental rights. The Fundamental Rights Enforcement Rules, for instance, was made by the Chief Justice of the Federation, which is a form of legislation. And there are authorities, for instance, Fahimi and Abacha, where the Supreme Court has said that the provisions of fundamental rights enforcement rules, they enjoy constitutional, flavors. And
Rules
the making
rules are procedural, not substantive. They are
yes,
procedural, not substantive. They only guide litigant as to how to go about pursuing his reliefs. They do not themselves offer the reliefs. Do you understand?
Yes, sir, I agree, sir.
So somebody might confront you that no, that is not what we mean by lawmaking. Their power to enact practice and procedure.
Yes.
Okay, is given, and is part of their judicial function. But we are talking about the power to say, there is this example I normally give of 2 people who are fighting over who was entitled to retain the custody of a woman. One said they were arguing that before the ballet of a community. So one said, I paid her dowry. The other one said, I impregnated her. And so under customary law, I'm the father of the baby in her womb. And so the question was, who would have the custody of the woman? And the ballet, who was supposed to act as the arbiter, the judge, he took a biro and touched his face with it 3 times and said, this biro, I will give it to any one of you who is able to provide me with 5,000 naira. At the time when money had value, and that person, whoever gets this value goes with the woman. Okay? Now, you and I, when we look at that, we say that's not judging. Or can we call that judging? Can we call what he has done judging? Hello? What the Bale had done, no matter how crudely you want to define
His judgments.
adjudication, is it adjudication?
Of course it is. Same thing King Solomon too did, so looks alike.
No. Solomon applied wisdom in his own case now. Solomon applied wisdom in his own. Anyway. What we are saying is that the Bale had no rules to follow, or if he had rules to follow, he did not know them. Only two things would have happened in the Bale's case. Either he had no rules to follow, or he was not willing to follow them. The modern courts, I'm not saying that you cannot find a very hard-headed judge that will be influenced by something different from the law. But he will at least pretend that he's following one law or the other. Do you understand me? He will pretend now. He might give a wrong interpretation to the statute. He might make a wrong inference from the facts, but he would at least pretend that here is the law that I have applied to arrive at this ruling. Okay? So that is probably the reason why judges will hide under the excuse that my hands are tied. So when women said his hands are tied. My hands are tied, though. I've only applied the rules. Nobody gave me the task of making laws. My task is that of applying the law that has been made by someone else, the legislature. So that is the one argument. What is the other argument? What is the other argument? From a jurisprudential perspective, can you review your knowledge of American realism?
Hello, sir.
Yes.
I do believe that lawyers make laws, and I want to learn. Sorry.
We are not talking about lawyers.
Sorry, it's a slip of tongue. Judges make laws. In the words of Professor Oliver Worms of the Realist School of Thought, he said the prophecies of what the court will do are nothing more pretentious, is what I mean by the law. For Oliver Wendell Holmes, he believes that it's the court that makes the law. Whatever the court says the law is, that is what the law is. And we've seen over the years, judges have, in a way, created laws from their judgment. They've set down precedent that even the legislature, the executive, and by extension, the larger society have followed. Before now, in the case of Roe and Wade, you could see that there were many abortion laws in the US until the Supreme Court of the United States of America said no, that abortion, the right to commit abortion, is a woman's right. Before 1973, 22nd January 1923, there are many ongoing abortion laws. A lot of persons have crusaded whether abortion laws should be.
Good. I don't want, forgive me for halting you on your track. But even those decisions, were they not based on some provisions of the American Constitution that they were construing for the first time? So if you want to argue that, look, they didn't make any law, they did not make any law, they were confronted with state abortion laws in the light of the individual's entrenched right to personal liberty. And they seem to have said that the one overrides the other, the latter overrides the former. So you want to put it in a way that they did not make laws, but they applied laws. That's the way you look at it.
Okay.
But
So
the realists gave you a foundation for their position. What is their foundation? What is the foundation for that position? One of them said that he's going to look at it from the perspective of the common criminal.
okay.
What did he say? Can you remember what he said?
No, I can't remember, sir.
He said, look, you find in the statute books prescriptions for sentences or offenses. And you will find that those prescriptions are maximum. In reality, you will find that the judges tend to hover around a given number of years. So the everyday criminal who is not a stranger to criminal trial would have had a table in his mind that if I merely stole, that won't get me more than 2 years. But if I robbed, if I forcefully take with threat of injuring the owner, they might give me some 2-3 more years. And it's not going to be more than that after all the grammar that they have blown and all of that. It's not going to be more than that. So he's not an occasional criminal. He's a criminal of all types. And he goes to court, is subjected to trial almost all of the time. And he knows what is given. So, for such a criminal, he already knows the law. He knows the law more than even the lawyer. He can tell you that what I have done is 3 years. I'm not likely to get more than 3 years. Okay?
Yes,
So
sir.
for him, until that your so-called black and white of the law is applied to give him sentence, there is no law. The making of the law is in the sentencing. So that is the way the realists presented their definition of law. We tend to make them conclude that judges make law.
Okay.
Do you understand?
Yes, sir.
Why is it that, why do we have a theory we call declaratory theory of precedence? Declaratory theory of precedence. How many of you have come across that theory before? Declaratory theory of precedent. You've not come across that theory before?
No, sir.
Now, the declaratory theory of precedent simply says that, look, because judges do not make law, when there is a landmark decision, you cannot give it a transitional effect so as to say that the law changed after so decision. Because for all intent and purpose, what the judge is saying is that what he is saying has always been the position of the law. It's only that this is the first time you are seeking judicial opinion on the matter. So, but because as it has been said of the legislature, that the legislature, it is that not only has the power to say that black is white, but that black has always been white. I'm quoting Lord Denny in one very interesting conflict of law case on time factor. He said, look, our legislature can tell us it is part of the latitude that the law has given to them. They can tell us not only that black is white, but that black has always been white. What we knew to be black, they can tell us that it has always been white. That is within their power. The judiciary doesn't have that power. The judiciary can tell us that no, you have been perceiving it to be white, but it is actually black. So how do you allocate a transitional timetable for their judgment? How do you say that after the Supreme Court pronounced the judgment in A and B, the law changed? Procedural speaking, you will be wrong. Because even the Supreme Court will not say, I'm changing the law. They will say, no, your understanding of the law is wrong. This is the law. So it is the understanding of the law that may change with judicial pronouncement, not the law itself. If you go by the position that judges do not make law, they only interpret or apply it. Okay? Any other comment before we go?
No, sir.
So let the meeting among us go and
Hello, sir.
their past.
Hello, sir.
Well, at least we will concede that to them. We will not behave like our brothers in the north who cancelled the academic session because of Ramadan.
Hello, sir.
Yeah?
From the historical point of view, historical jurisprudence, we know that time evolves. Historical school of thought, time evolves. And then circumstances changes. The way we perceive event changes with time. And then in criminal law, we believe that a crime exists only when it has been promulgated or made through the act of parliament. Just like those crimes that have been enshrined or defined in the criminal code and the penal code in Nigeria. Sir, I want to ask you directly, sir. sometimes the Roe and Wade case mentioned by one of the presenter changes, because in Nigerian constitution there is a right to life, and that right to life means a life must be protected. But in the instances of the Roe and Wade, it was decided that the women have right to abort their developing baby in their womb in order to survive. The judge sitting over that case has been able to, make a new precedent from the old one. There is a departure from the former precedent to a new one. Though, of course, from the 1999 Constitution, the legislature is given the power to make law. However, the judiciary is given the power to adjudicate. But in order to interpret the law, by extension, they make new laws in which it applies to the case in the court, or that also change the perception of the public or scholars in the field. Sir, I want
When
you to
sir, when you are looking at it that way, you are becoming a realist, an American realist. That's exactly the reason why the American realists said you are talking if you say that judges don't make law. Because they look at this practical implication of what the courts do. You understand? But if you take the argument vis-a-vis the argument of the judges themselves who say that they are not lawmakers, you will see that the two arguments can be presented in a parallel way. Both of them can be two absolute truths that do not affect one another. If you see lawmaking in the sense of decreeing the consequences of a conduct, okay? You cannot, in black and white, if you see it as decreeing the consequence of a conduct or omission in black and white, then you are elementary correct to say that that's not what the judges do. In the first instance, the judges will not intervene in anything until you present the case before them. Okay? So, and no matter what their personal opinion is, and no matter how they are influenced by their personal opinion in arriving at the decision, they dare not say that this is my own view. They will pretend that they are applying or interpreting some laws. Okay? But if you are now looking at it from the perspective of the realists who say their psychological hunch is what determines the outcome of decision. That if you go before a judge that was robbed by child robbers, and is to determine whether to give soft landing to somebody of age 16 to 18 on the ground of age, he might not agree to give any such soft landing. The example was given of a judge. The example was given of a judge who said, oh, we should be forgiving him so that he becomes a big robber. So these are the issues. These are the issues. We can revisit this matter next week when we round up with stare decisis. Okay? So I see you next week.
Yes, sir.
Yeah, thank you, sir. God bless you, sir.
Thank you, sir.
Bye-bye, sir. See you next week, sir.
Good night, sir.
Thank you, sir. Good night, sir.
Good night, sir.
Thank you so much, sir.
Hello, good evening. Can anyone hear me?
Yes, we can.
Okay, please. I hope everybody have dropped their names. I'll just probably call out the ones that I have a record. Sorry. Okay. Precious Barituka, Madu Abuchi Ndukwe, Omotayo Toluwani, Osaya Telma Ifeyiwa, Emmanuel Etetuve, Shaba Olakemi. Okay, Shaba Olakemi, Elibute Seriki Feyisara, Blessing Itoa Ahmed, Olubumi James Daramola, Aris Basi Mechi, Oladele Amoto Janet, Oluwolare, Ironwood Judith Chidema, David Obeidi, Efe Korazon, Mohammed Adam, Luke Okonkwo, Aderonke Jalade Akinwande, Collins Mbakwe, Zainab Mohammed, Oyewale Noah Oyedotun, Peace Ugide, Adejokun Oluwabumi, Omotayo Blessing, Falare Josephine, Olamide Obajimi, Sule Genevieve, and Ezine Unumajuri. If you didn't hear your name, please confirm. If you've heard your name, you can exit.
I didn't hear my name. Good day, Miss Mary.
Your name?
Olashubomi. Olashubomi Adegbemisoye.
I didn't see your name. It's not here. Did you drop it? Drop your name and your matric number now,
Yeah,
because
that's
the host is going to log us out very soon. That's why. So quickly drop the name.
I'm doing that. I'm copying it again.
I believe the names I've called, everybody have heard their names.
I'm even unable to drop the chat. Okay.
Go to the chat and drop it.
Yes, that's what I'm doing. Thank you, Don.
Okay, confirm and let you know. Just a bit. Okay. Olashubomi.
Yes, please.
Adegbemisoye. Okay, all right. It's recorded.
Thank you very much. Have a good day. Bye.
You too. Bye.